Good evening. At this time, I'd like to call to order the Planning Commission meeting of July 6, 2026. For viewers watching at home, some members of the public may be participating via video conference or teleconference. Please stand and join me in the Pledge of Allegiance. I pledge of allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, liberty, and justice for all. That feels good to do that after our 250th birthday, right? Right? Will the secretary please call the roll?
Commissioner Ferris?
Here.
Commissioner Lanson is absent. Commissioner McMahon? Here. Vice Chair Buss is absent, and Chair Tyler Kettlehut.
Here. Tonight we have with us Planning Division Manager Stephen Kearns. Are there any written comments, announcements, or continuances at this time?
We did have one supplemental packet that was distributed to the Planning Commission this afternoon and also posted online. The packet contained correspondence related to items 7A and 7B. That is all. Thank you.
One other item, staff is requesting that item 7A be continued to address an error on the agenda.
Okay. Would one of my fellow commissioners like to make a motion to continue that?
I move that we continue 7A to a date to be calendared in the future. Is that correct?
Yes, I suspect it will be at the next regularly scheduled Planning Commission meeting.
Do you want the motion to specifically do that, or allow staff to properly notice it and put it on the agenda?
Yeah, we don't need a date certain, just to continue it to the next available date.
Okay. I move that we continue the hearing. No specific date.
Okay. Could you please prepare us for a vote?
Commissioner Ferris?
Yes.
Commissioner McMahon?
Yes.
Chair Tyler Kettlehut?
Yes.
Motion carries 3-0 with Commissioners Buss and Lanson absent.
Thank you very much. Now is the time for public comment. Do we have any public comments?
No.
All right, thank you. All right, we're going to skip 7A then. I'd like to open the hearing. Will the clerk please open the public hearing on 7? Oh, I'm sorry. Consent calendar. We next have the consent calendar with the minutes of the June 22nd, 2026 Planning Commission meeting. Do any of my fellow commissioners have any comments or a motion to approve the consent calendar?
I move that we approve the consent calendar.
Will the secretary please prepare us for a vote?
Commissioner Ferris?
Yes.
Commissioner McMahon?
Yes.
Chair Tyler Kettlehut?
Abstain?
Motion carries 2-0 with Commissioner Lanson and Buss absent and Chair Tyler Kettlehut abstaining.
Thank you. All right, now we'll open the public hearing. Will the clerk please open the public hearing on 7B?
Hearing having been advertised as required by law is hereby open to consider Agenda Item 7B, Special Use Permit, SUP 2024-70021, to allow the operation of a religious assembly use within an existing industrial building and allow the alternating use of parking facilities located in the Industrial Park M1 zone and Rancho Conejo Industrial Park SP-15 area at 2639 Lavery Court, Unit 5. The applicant is Louis Linen for Southern California Conference of Seventh-day Adventists.
Thank you. Presenting on behalf of staff is Assistant Planner Nicole Katz. And before we proceed, do any commissioners have any ex parte communications to disclose? All right, thank you. Nicole?
Thank you. Good evening, Chair, Planning Commissioners, and members of the public. Tonight we're here to present a request from Pastor Luis on behalf of the Southern California Conference of Seventh-day Adventists. I'm joined by city staff from the Community Development Department to answer any questions that the Commission may have in regards to the request for the operation of a religious assembly use and for the alternating use of parking at 2639 Lavery Court, Unit 5. The item before the Planning Commission for this evening's consideration is to allow the operation of an assembly use within an existing industrial building and to allow for the alternating use of parking facilities at an existing industrial park. The subject property is located within the Industrial Park Zone, also known as M1, and is also within the Rancho Conejo Industrial Park Specific Plan 15 area, SP 15. Per SP 15, contained within Thousand Oaks Municipal Code, Title 9, Appendix A, Section 4B3, a special use permit application is required to permit a religious facility, synagogues, and other places of worship within the SP 15 area. Thousand Oaks Municipal Code, Section 9-4.2403, states that the Planning Commission may approve alternating use of parking facilities where parties wish to cooperatively establish and operate parking facilities, and where these uses generate parking demands primarily during hours when the remaining uses are not in operation. Additionally, Thousand Oaks Municipal Code, Section 9-4.2803C, grants the Planning Commission the authority to approve special use permits if the Commission can make the following 5 findings. 1, the use is consistent with the general plan and any applicable specific plan or redevelopment plan. 2, the use complies with all applicable laws, regulations, and policies, including the Thousand Oaks Municipal Code. 3, that the use will not be detrimental to the public health, safety, or welfare. 4, that the use conforms with the provisions of the California Environmental Quality Act. And 5, that the use is compatible with other land uses in the vicinity. The subject property is Lot 8 of Tract Number 2456, which was approved by the County of Ventura in 1976. On February 4th, 1983, Development Permit 283 was administratively approved by the Ventura County Planning Division, which allowed for the development of an industrial complex. Over the years, a series of modifications were also approved by the County of Ventura, which brought the development to its current configuration of 3 single-story detached buildings with surface parking around the perimeter of and adjacent to the buildings. On May 28, 2008, the City of Thousand Oaks Community Development Department administratively approved Land Division 2007-70480, which converted the existing industrial complex into industrial condominiums, allowing for individual ownership of each industrial space on the site. Per the applicant, the site was purchased in 2015, and operation of the Newbury Park Spanish Seventh-day Adventists began that year. At the time their operations were commenced, a special use permit was not obtained or requested. On July 8, 2024, an alleged municipal code violation was submitted to the City of Thousand Oaks pertaining to a business operation which resulted in the church's use occupying more parking spaces than allotted to them by their property management company. In response, the city's Code Compliance Division opened an investigation, issued a notice of violation, and directed the operator to cease the assembly use until they obtained a special use permit to allow for a religious facility at the project site. At this time, I would like to offer the Commission a brief overview of the application's processing. On October 16, 2024, a representative of the applicant team submitted the special use permit to the Community Development Department. On November 13, 2025, the notice of application mailer and signage was posted on the property, and the mailers were released. On January 12, 2026, the notice of hearing sign was posted on the site, and mailers were released in anticipation of the January 26, 2026 Planning Commission hearing. At the January 26, 2026 Planning Commission hearing, the item was continued to a date uncertain to provide the applicant with additional time to bring forward information to support the request for the alternating use of parking facilities. On June 22, 2026, the notice of hearing sign was posted on the site, and mailers were released. To date, staff has received several phone calls and emails from members of the public expressing concerns about the availability of parking. All items of written correspondence are included in attachment number 7 of the staff report and within the supplemental packet, which was circulated this afternoon. Staff responded to all inquiries in a timely manner. The modifications to the tenant space would be limited to interior improvements only, contained within the volume of the suite. On the first floor, the existing storage closet would be repurposed into a new bathroom, and the existing bathroom would be upgraded. On the second floor, the existing storage mezzanine would be repurposed into 3 office spaces. The applicant has affirmed that no exterior improvements are proposed or intended for proposal in the near future, nor have they been performed in the past. The Thousand Oaks Municipal Code requires that all uses in all zones within the city provide off-street parking in accordance with the ratios described within Municipal Code Section 9-4.2402. Section 9-4.2404B2 states that all parking spaces must be located either on the same lot or parcel as the building or use they are to serve, or on a contiguous lot. Although the applicant's parking analysis indicates that an alternating parking arrangement may allow for the proposed project and all uses on site to comply with the city's parking requirements, the applicant has not provided the city with an agreement demonstrating that all parties with parking rights in the business park, including the Lavery Court Property Owners Association, who controls the business park's parking area, wish to cooperatively share their on-site parking. Further, the applicant has not provided the city with an agreement or other evidence that it has the legal right to utilize parking spaces on a contiguous lot. Based on the Thousand Oaks Municipal Code parking ratios required for the applicant's proposed use, a total of 39 parking spaces would be necessary. The amount of parking spaces required for all other uses within the business park amounts to 97 spaces per our code requirements. Between the parking spaces required of the applicant's use plus all other uses sharing the parking field, a total of 136 parking spaces would be required. Presently, the site contains just 85 surface level parking spaces. To address the parking deficiency, the applicant's options included 1, entering into an alternating parking agreement to utilize the on-site parking spaces per Municipal Code Section 9-4.2403, or 2, entering into an agreement with a property owner of a contiguous lot to use off-site parking spaces per Municipal Code Section 9-4.2404B2. The church's primary hours of operations are Saturdays and Sundays, 8:30 a.m. to 8:30 p.m. During that time period, 3 other businesses who use the parking field are in operation, and their parking requirements per the code requirements would amount to 20 spaces. Although the applicant's parking analysis indicates that an alternating parking arrangement may allow the proposed use and the 3 other businesses in operation on Saturdays and Sundays to comply with the city's parking requirements, the applicant has not provided the city with an agreement demonstrating that all parties with rights in the business parking area, including the Lavery Courts Property Owners Association, who controls the parking area, wish to cooperatively share the on-site parking. Further, the applicant has not provided the city with an agreement or other evidence that it has the legal right to utilize parking spaces on a contiguous lot. As discussed at the beginning of the presentation, the Planning Commission is provided the authority to approve a special use permit if all of the 5 findings within Thousand Oaks Municipal Code, Section 9-4.2803C, can be made. Before concluding the presentation, it is necessary to note a brief typographical error found in the 3rd sentence of the 2nd paragraph within finding number 2. Presently within this portion of the draft resolution, it reads that the applicant, Southern California Conference of Seventh-day Adventists, owns the surface parking spaces. However, as evidenced in the CC&Rs, the Lavery Court Property Owners Association owns the surface parking spaces, not the applicant. Therefore, the 3rd sentence of the 2nd paragraph within finding number 2 in the resolution should instead read as, the applicant, however, does not own the surface parking spaces serving the industrial units. In conclusion, based on the information provided in staff's analysis of the application, staff is unable to make finding number 2, which requires that the project comply with all applicable laws, regulations, and policies, including the Thousand Oaks Municipal Code. The project has been reviewed in conformance with the Thousand Oaks Municipal Code, and it does not comply with Title IX, Chapter 4, Article 24. Section 9-4.2404B2 requires that all uses must provide off-street parking either on the same lot or parcel as the building or use they are to serve, or on a contiguous lot unless otherwise approved by the Planning Commission. Additionally, all uses are required to provide off-street parking per the ratios described within Section 9-4.2402. Because the proposed project cannot demonstrate that it can provide the off-street parking required by the municipal code, finding number 2 cannot be made. Staff concludes that the project is not in compliance with the Thousand Oaks Municipal Code, specifically Title IX, Chapter 4, Article 24, since the applicant has not been able to demonstrate that they have the legal right to use the requisite number of parking spaces as required by the Thousand Oaks Municipal Code for their proposed use. As such, staff recommends denial of this permit by adopting the draft resolution as amended to reflect the language changed to sentence 3 of paragraph 2 within finding number 2. This concludes my presentation, and I am available to answer any questions. Thank you.
Thank you, Ms. Katz. Are there any questions or comments from my fellow planning commissioners?
Thank you. Thank you for the presentation. I just want to double check some of the details that you had just mentioned, just so that I'm clear on it. The change that you're referring to is a change to attachment 4, the draft resolution that was in the packet. And if I'm reading this right, first paragraph on page 4, midway through, the applicant, it says the applicant, however, does own the surface parking spaces. You're saying it should say the applicant, however, does not.
That is correct, yes.
Okay, so that's the amendment you're requesting.
That is the amendment, just that one amendment to that one sentence.
Okay, perfect. Also, you mentioned in this sharing parking analysis, that is the applicant's parking analysis. They have given an indication that they think it can work, but because there's no agreement from the other owners of the spaces to whom they would be sharing with, we don't know what they are thinking, and they're not in agreement with whatever is being presented to us tonight. Is that right?
That is correct. So essentially, the applicant has provided their parking analysis showing all of the uses, their square footages, and hours of operation. And that's how we arrived to that. A possible resolution could be that shared parking arrangement. On paper, that does pencil out. However, in order to pursue a shared parking agreement, all of the owner of the parking field has to sign off on the application and authorize that they're willing to cooperatively establish and facilitate that shared parking. In this instance, this is a little bit unique. These tenant suites are individually owned. So in our instance, the property owner, our applicant, Pastor Luis, on behalf of his congregation, he owns just his unit, unit number 5. The CC&Rs that are associated with the property specifically indicate that the common area is owned and maintained by the Property Owners Association, and the common area definition does include the parking field. So in this instance, since we have not received authorization from the Property Owners Association, we could not support the request for an alternate use of parking facilities because there's not that cooperative agreement.
Okay, thank you for going into detail on that. Thank you.
Commissioner McMahon, any questions?
So from reading my packet, not only did they not have an agreement, but we have a letter from the Property Owners Association saying that they don't want it. Is that correct?
That is correct.
Thank you.
Any further questions? All right. Now we ask for the applicant or the applicant's representatives to speak. Am I correct that the applicant is not speaking? I don't have a card for the applicant. Okay.
No cards.
All right. Thank you. Now we'll go to public comments. We would call Gary Gagliardi, I hope I've gotten that right, and you will have 5 minutes to speak, please.
Good evening, Madam Chair, Commissioner, and City staff. My name is Gary Gagliardi. I am the president of the Lavery Court Property Owners Association. I'm also the owner of Unit 11 within the Lavery Court Industrial Park. Thank you for the opportunity to speak on this evening. Before I begin, I want to make one point absolutely clear. This case is not about religion. The association does not oppose churches. It does not oppose religious worship. It does not oppose the Seventh-day Adventist Church. If this application involved a banquet hall, a private school, conference center, or any other type of large gathering, we would be here doing the exact same thing, making exactly the same argument. This hearing is about whether the applicant satisfies the requirements of the Thousand Oaks Municipal Code and whether this commission can legally make the findings required for approval. After reviewing the staff report, the proposed resolution, the recorded CC&Rs, and the municipal code, we respectfully submit that the answer is no. Lavery Court was approved and constructed as an industrial business park. In 2008, we've been through the history of it, so I'm just going to skip through it, that our CC&Rs are not merely a private agreement, are not merely private agreements between the owners. They're required as a condition of the city's approval of the industrial condominium conversion and establish the legal framework governing ownership, parking, and use throughout the development. Every owner purchased property subject to these recorded restrictions, and every owner relied upon them. One of the most important facts in this case that's overlooked, the applicant owns Unit 5. The applicant does not own the parking lot. The CC&Rs define the parking lot as common area and owned collectively and administered by the association. That distinction is critical. Ownership of Unit 5 does not create ownership of parking spaces. The recorded CC&Rs independently restrict this use, and there is another provision in the CC&Rs that deserves particular attention. In section 7.1 on page 22, it provides that no condominium may be occupied or used for any purpose that under the city's parking standards creates a parking demand exceeding one parking space for every 500 square feet of gross floor area. His unit is 1,721 square feet. Applying that formula, that means 3.44 parking spaces, or we round up to 4 parking spaces in total for use for Unit 5. Yet the city's own proposed resolution concludes that the proposed religious assembly requires 59 parking spaces. This is not a modest parking shortage. The proposed use requires nearly 15 times the parking allocated. Even if every one of the other 4 allocated spots were available, the applicant would still be 50 spaces short. The city's own staff reached the same conclusion as she noted. The Community Development Department carefully analyzed the application. They concluded that he's not demonstrated the legal right to use the parking spaces. The proposed resolution before you makes several important findings. The applicant does not control the parking. The association has not allocated sufficient parking. The association has not authorized cooperative parking, and the association has not approved alternating use of the parking facilities. Therefore, the commission cannot approve the request. There's one other point I want to touch on that's mentioned in an email that Mr. Linehan made. I want to make a factual correction. He said in his December 2nd, 2025 email that he stated that he requested to speak at an HOA meeting but was denied. Now, I was a member of the Lavery Board since 2012, and I was at a meeting that Mr. Linehan actually attended. Myself, at the time we had a different president, and I actually have with me the minutes of that meeting in which on Wednesday, January 25th of 2017, Mr. Linehan spoke regarding Unit 5, Seventh-day Adventist parking. A different pastor from his, I'm sorry, not Mr. Linehan, but the pastor, Carlos Verona, and 3 other church members, which one of them was Mr. Linehan, attended the meeting and pursuant to the CC&Rs was told about the parking facilities. Now, this goes back to 2017, almost 10 years ago, when they were conducting religious services. I had been calling the city enforcement for almost 10 years. The previous person, Jeff Stoddard, that was in charge, was trying to shut this down. And it's created such a safety hazard in our property, as you saw by the aerial view, the way the parking is. It's not designed to have children running around in an industrial park when we've got trucks and cars coming through. And yes, there may be some businesses that are open on Saturdays, but the majority of these units are individually owned by people in the area that purchase these things, that brought revenue into the city, that actually use them on the weekends. One of them is here that's going to speak as well. Some of us are car collectors. Some of us have our own workshops. We drive in and out of the facility all day long. And there's been many times where it's created a very dangerous situation. So what I'm asking is that we just stick to the letter of the law and we take the emotion out of it and say that as the association, we are not going to give the permission to use the parking. At this time, I'll answer any questions if you have any.
Thank you. Do any of my commissioners have a question? Thank you very much. Next, we'll hear from Mark, and I'm going to mispronounce this too, Innocenzi. Did I get that right? You have 5 minutes.
Good evening. Thanks for the opportunity to speak. I'll be brief. I own the industrial condo 2631 number 8. It's in the Lavery Court Business Association. As you've probably seen from the aerial photographs, it's mostly small shops, small businesses, 30 units, very limited parking. We do electronics restoration. We have people coming, but I generally do it by appointment. I'm allocated 2 spots, so I try not to allow too many people to come over at one time just to avoid congestion for the other owners. I do think on weekends that there's more than 3 businesses operating, maybe not continuously during the hours of 8:30 a.m. to 8:30 p.m., but there's other people that need to come and go. So the business park is really not set up for any high-volume traffic. Okay, as Gary said, if it was something that generated a lot of foot traffic, any kind of business, okay, it wouldn't be a very good fit. I myself am very pro-religion, but I'm hoping that the Adventists can find a more suitable location for their services. And I know from being over there on the weekends, like Saturday mornings and so forth, even recently, they never stopped having their services, even though they were requested to. So it's not clear that they're going to be very cooperative with other demands. So we just don't have the space, we don't have the parking, and we're really not set up for a lot of people. And there's a lot of people coming to those services, and it does create a significant burden for the other owners. So again, I'm hoping that they can find a more suitable place, and I think that the Planning Commission's conclusion is correct, that the petition should be denied, or the special use permit. So thank you.
Thank you very much. We now go back to the staff for follow-up comments.
Thank you, Chair. Just to briefly address the commissioners, in response to Mr. Gagliardi's comment, he was correct. There is a section on page 4 of the resolution on the second paragraph on page 4 where it says the religious facility use requires a total of 59 parking spaces. That is erroneous. For the record, it should be 39 parking spaces. However, that does not change staff's conclusion or recommendation. And then in response to our second speaker, Mark, his comment, just to provide the commission with some insight, he had remarked that he was suspicious if they would be compliant, with next steps if this application is denied. I have confirmed with the Code Compliance Division that if this application is denied this evening, they'll continue proceeding down their code compliance case, and they would issue another notice to the property owner requesting that they vacate or cease operations of this use, since they did not receive or may not receive the use permit, depending on your vote this evening.
Awesome, thank you. Since the applicant didn't appear, we won't have any rebuttal comments. Going to close the public hearing now, and I will now open up the floor for discussion and/or a motion. I only have to turn this way today, which is nice. I don't have to go this way today.
A convenient meeting setup for today. I am compelled by staff's staff report, and if it makes sense, I'll go ahead and make a motion just for us to be able to discuss it. I move that we adopt a resolution denying the request based on the findings contained in the resolution as amended by staff. Is there anything else that staff needs in the motion?
I would just like to confirm that we're adding the word "not" in the resolution and revising the required 59 parking spaces to 39. Is that correct? So just
That is
make
correct.
sure that we're
Those
talking
are
about
the two amendments
those two
staff is
amendments.
recommending, that
Yes.
those are included implicitly
Thank you.
and explicitly. Yeah, so that's it. I like I said, I'm compelled by the nature of this, and I do think in some ways, if they're very successful in the nature of the use, it's going to only lead to more parking and more use, which is not set up for how it has been conditioned and approved. And I do think for this reason, it's the appropriate outcome for the commission. I will say in this also, just as a point of reference, I've been on the Planning Commission on and off since 1999. This is the first time that I can remember that the applicant did not show up for their own application.
Interesting. Commissioner McMahon?
Okay, so it's a little confusing because we don't usually have a motion to deny. So I just want to make sure, if I vote yes, that means I don't want to approve the special use permit?
That's correct. A yes vote is a vote to deny the application.
Okay.
No, good, double negative there. And I would agree that, what they've described here in terms of it hasn't been set up for that. It hasn't been set up for that. And when, especially the thing that was most compelling to me is talking about the kids running around the parking lot, and that's why we have the laws. That's why we have the municipal code. So I would support your motion. Could you please set us up for a vote, please?
Commissioner Ferris?
Yes.
Commissioner McMahon?
Yes.
Chair Tyler Kettlehut?
Yes.
Motion carries 3-0 with Commissioners Buss and Lanson absent.
Any aggrieved party who wishes to appeal the Planning Commission's decision may do so by filing an appeal with the Community Development Department within the next 10 days. Do we have any department reports this evening?
No, we do not.
All right. Now is the time for commission comments, and any AB 1234 reports. Are there any comments from my fellow commissioners? I don't know why I'm looking that way. All right. And so, Mr. Kearns, do you have any follow-up items, announcements, or upcoming issues to share with us?
Yes, thank you. At tomorrow night's city council meeting, the council will have the second reading of the downtown project ordinance. After the summer recess on August 25th, there will be a public hearing on a decision you made here for a lot line adjustment on Upper Ranch Road. That decision was appealed to city council. For item upcoming planning commission schedule on August 24th, we will have a public hearing for the rent increase for mobile home parks. That'll be for you, and that's the only item so far scheduled. Thank you.
All right, and we can all get back to our soccer game. Thank you. We will now adjourn to the next meeting on August 24th, 2026 at 6 p.m.